is no such thing as federal expungement. The only process that there's two little exceptions to that. One is where the arrest or conviction was invalid or subject to clerical error, which I think we can all agree should be fixed. Another exception, though, is if there was deferred adjudication and expungement. There's an expungement for a first misdemeanor drug possession if the person was under 21 at the time of the offense. Most often this is not federal stuff, perhaps sometimes tribal. But usually the people that are involved in the federal justice system and charged with federal offenses are not dealing with misdemeanor first-time drug possession for under 21. So essentially when someone calls me up and asks me to have their federal offense or record expunged, I have to tell them that I can't help them. The only thing that's available for those people is a presidential pardon. And so those are very, very difficult to get. I'll talk a little bit about that too. But so from 2009 to 2014, 31 states plus the District of Columbia have enacted some type of legislation to broaden expungement eligibility. So state offenses, people who have criminal records, there has been a shift as we get more into the electronic age to try to help people clean up their records and to broaden expungement eligibility. There's been really four main approaches to doing this in states. One is to apply expungements to broader categories of offenders. So for perhaps making certain types of offenses eligible where they were previously not, certain levels of offenses eligible, such as felonies, where previously they were not. One has been to reduce waiting periods. So a lot of the expungement laws that are on the books for various states will require certain periods of time to wait before eligibility. And there's been some shift to try to reduce some of those periods. A lot of times the eligibility periods, by the way, are after somebody has been discharged from probation or parole, or however long their sentence. They've been discharged from their sentence. And unfortunately, sometimes those periods themselves can be very, very long periods, 20 years of probation. So it can end up being quite a bit of time that's passed since the commission of the original offense. Another tactic has been to shift the burden of proof. So essentially making expungement presumptive rather than permissive. You know, coming into court and essentially instead of having to say, Judge, I've rehabilitated, instead coming into court and having a prosecutor or the state show why someone should not get an expungement. There's a presumption that the person will get it if they've met other specified requirements that are outlined. The last thing is to clarify or expand the scope of expungement. We've talked a bit about what an expungement does, whether it's an expungement perhaps in name only, where the court has said, yes, this person is being granted an expungement, but looking beyond that as to what is the scope of that. What records are actually removed? Are there records that are going to be out there that are still able to be found? And if so, certain legislatures in states have said, let's expand the scope. Let's cover more records that are publicly available as subject to this expungement. So broader categories of offenders, as I mentioned, expanded to severity levels, felonies rather than misdemeanors, more types of offenses, applied to those with criminal history just beyond one offense. Florida, for example, has a statute that says if you want to get something expunged, it has to be essentially the only thing on your record. If you have another offense, you're not eligible. Minnesota just completely overhauled their expungement laws. They've basically said now if you have any petty misdemeanor, any gross misdemeanor level offense, that's eligible for expungement after certain waiting periods. There's also a list of 50 felonies that now qualify. Prior to 2015, when our new law took effect, expungement was very, very restrictive as to the types of cases that it applied to. And so there's, again, been this push of saying, let's still give judges discretion, but at least allow the opportunity to be there for someone to get a full and meaningful expungement. Reducing waiting periods. Generally, again, they're required to show rehabilitation. So, as I mentioned, some states have really long waiting periods. If you're on probation for 20 years and then you're eligible for an expungement 10 years after that time, that's 30 years after the commission of the offense. And oftentimes, by that time, after the commission of offense and 30 years later, the offense itself is really not such a huge impact. I mean, the effect of having that on your record has really been mitigated by that point. So trying to get people in when they're really dealing with issues where their record is really affecting them. Shifting the burden of proof. Another part of this process, too, is to try to streamline some of it. Minnesota, again, as an example, has said that they will streamline the process and shift the burden to the prosecutor in some situations to come in and demonstrate that an expungement is not warranted rather than a person having to come in and demonstrate that they're deserving of it or that it is warranted. Part of that is to say if a prosecutor does not intend to meet that burden, that there doesn't need to be a hearing. You know, people don't need to show up. I myself have had hearings where I've shown up and everybody sort of looks around and says, is anyone going to come and speak against this? No? Okay, then the judge has no choice but to grant it. And so some of these things, to make the process more efficient, also too, to streamline it so that it's more available to people who are of low income, who perhaps don't have the resources to hire an attorney to go back to court and have this done. You know, it's sort of a catch-22 because a lot of times people are in a situation that's pretty dire. They need to get an expungement in order to get employment, to make money, to make ends meet, make a living. But they can't get that expungement because they can't do it themselves for various reasons, and they need to hire an attorney, so they need to get money. So it's kind of this cycle. So there's also been some efforts to make the courts more accessible for people in these types of situations in particular. Another thing to think about, too, is to perhaps try to negotiate future expungement in plea deals. There is the possibility, and it varies by state, but sometimes there is the possibility to say, if my client meets certain requirements over the time that they're on probation and perhaps even beyond, if they meet the requirements otherwise of qualifying for an expungement, would that prosecutor either agree to the expungement in the future or at least agree not to take any position against it? There is some thought of trying to look forward when dealing with the initial disposition of a case. Sometimes it's totally premature. Prosecutors a lot of times will not entertain the idea because they just can't predict the future or don't have the authority to negotiate that within their office. But it's something worth asking for. It's another piece. And oftentimes for the client, it can be huge. I often say that half the battle with criminal defense is dealing with the original charge itself and getting that person through the whole situation, the criminal justice system. But the other half of it is then what to do moving forward in the rest of their life, being able to put it back together. And I would really strongly say not to underestimate the value that that provides for a client. So in sealing records, we talked about the scope of it, sealing records versus the destruction of records, or versus even the reversal of a conviction. You know, really taking a look at when we talk about expungement or setting a conviction aside or some other cleanup process, expunction, what does it actually do? And can we make this stronger for people so that it's a more meaningful remedy? We're really truly putting the genie back in the bottle more than maybe is available to them now. So, and I mentioned too that, you know, sealing records only can create problems for people. You know, we've talked about what to disclose and what not to disclose, but there's also issues with regard to firearms, which I'll talk about here in a second. You know, if the expungement does not reverse a conviction, a lot of times someone is still subject to a firearms prohibition or still subject to some of the collateral consequences that flow from having that as a remaining conviction. Student aid, for example. Expunged records of an adult drug conviction are not considered. Drug possession, 1 year, 2 years, lifetime. Drug sale, 2 years, lifetime. So the point is, you know, FAFSA, the student aid, they can look at even records that have been expunged. They can potentially use them in situations depending on how much time has passed. And so there still can be collateral consequences that can flow from just sealing records instead of actually completely reversing a conviction.